Hello folks, welcome back to the Edupedia world, and I am Abhinay Gupta. So today again we are continuing with the winding up of the companies, and for this we are considering the provisions of Companies Act 1956. Right with that? So we were already discussing the concept of contributories. We have had 2 lectures on the topic already. Right? And there was a very small part that was due and we will be covering it up in the current lecture. Right? So basically I would take you through those 2 lectures. We will just see what are the topics that have been discussed, and if you have not witnessed those lectures, please go back, see them so that your concept is cleared, and over here we are just concluding that topic. So it has been a stretch of 3 classes, right? 3 lectures, and that was required. Once you go back and listen to those lectures, you will understand the concept behind. Right? And at the end we'll also discuss 2 questions that have been asked in your previous examination. 2 easy questions, right? So what have we already seen is the concept of contributory, who the contributories are, right? They are the person who are liable to contribute to the asset of the company. They have 2 lists, list A and list B. What are they? Has already been discussed. The nature of contributory is liability. Absolute liability, the ex lege liability, what is ex contractu, and all these terminologies have been discussed in the first lecture. Right? So this is what we had covered in detail. The nature of contributory liability, all these 4 natures was covered in detail with examples in the first lecture. Right? So if you have missed it out, please go back, see it, and if you have been continuing, well and good, we'll step ahead with this lecture. Then in the second lecture we discussed about the list of contributories. The present member, past members, directors and managers with unlimited liabilities, legal representatives of the deceased member, official assignee of insolvent member, liquidator of the member body corporate, and the person who is party to fraud as per section 542. So these were the list, and we discussed that the concept behind all these are that they are the members. So either they are the members, if they are not the members, they may have been past members if they have surrendered their shares, right? Otherwise, if they are dead, if they have been deceased, then they're legal representatives. If they are insolvent, then they're assignee, and if they were a body corporate and insolvent, then they're liquidator, right? So ultimately all these nature are evolving up because you were a member at one point of time, right? And the last part is that if you are party to fraud, 542, this is a separate thing, right? We have discussed all of these in the second lecture, right? Now we are left with just one very small topic that we will be discussing in the current lecture, that is, the contributories do not have the right to set off. So this is a situation where the contributory, the person who is liable to bring in the fund into the company, is also liable to take away. He's not liable, the company is liable to pay him something in return. Like for example, if a member had, for example, 1 lakh shares of a company, right? And the company made a call that was rupees 2 that was unpaid on that share. So this member is now liable to pay rupees 2 lakh to the company, right? And now suppose the company had also declared a dividend of rupees 50 paise per share. So that person is also supposed to get from the company 50 paise per share, that amounts to rupees 50,000. So what that person contends is that, listen, I am supposed to pay rupees 2 lakh and I am supposed to get back rupees 50,000. So why don't we make it a very simple transaction? I deduct that 50,000 and pay you the remaining 1.5 lakhs. The liquidator straight away denies it. Why? Because that is the demand of the law. You will have to bring in all your money. You will have to bring in everything that is due to the company because you are a contributory and your liability is an absolute liability. And it has risen. Why? Because we have already made a call. And it is an ex lege liability. It is not an ex contractu liability. It has risen by law and you will have to bring in because that is your absolute liability. That is the first contention, right? Second, that is because you are not standing in the priority list. You are not the overriding preferential payment people, right? You are the unsecured debtors. So where do you stand is at the end of the list. So if we are able to pay off all the other liabilities and we have some money left, that is only when your liability will be paid. So it is not sure that you will receive that 50,000, so you cannot set it off. So what the member was asked to do is to contribute that rupees 2 lakh because that was his liability to the company, and then stand in the list of the receivers. And as and when the list is being dispensed with, as and when the liabilities are being paid off, and there is surplus fund for you, we will pay off your debts as well. But if we have shortage of fund, we may not be able to pay your debt. That is why you're not allowed to set off. So if you try and understand what is the principle behind such denial as per the law, right? Then the law says that in any situation, if you are the person who is liable to participate in the fund means participate in the fund that the company has. That means you are a receiver, you are a creditor. Plus, you are also entitled to make the contribution. Sorry, entitlement is for the fund. You're also liable to make the contribution, right, for that fund. That means you are liable to make the contribution in that fund, and again you are entitled to take money out from that fund. So you will not be allowed to participate in that fund. You will not be entitled to take money out from that fund unless and until you discharge all your obligations, right? So first, we will consider you to be a contributory and then the creditor. So first of all, if you want something from us, dispense off with all your liabilities to the company, and then the company will see if it can dispose of its liability towards you. If you do not pay to us, we will not pay anything to you. So first, pay off all your dues, set it clear, right? And then you will be entitled to that fund. But when we talk about your entitlement to the fund, you will be entitled in the list of priority. You will stand in the list, you will stand in the queue. You're entitled to the fund, right? That is the procedure we are following. Stand over there. You are entitled, you will be receiving the money if we have surplus, right? But in order to be eligible to stand in that queue also, you will have to bring in that rupees 2 lakh as contributory. Otherwise, we will not allow you to stand in that list, right? That is the principle behind such denial. For this, you can also refer to the case of the Peruvian Railway Construction Company. That was a case, right? We'll not get into the detail because that case is not very important for you. But then again, you have exceptions for that scenario. You have 3 exceptions as you can see on the screen. An unlimited liability of contributory, unlimited liability of directors, and when the creditors have been paid in full. Yes, you didn't understand what we are talking, right? Because I didn't explain it so far. Now let us pick each one of them in detail. Number 1, an unlimited liability of the contributory. So first of all, we need to understand when does a contributory have the unlimited liability. That is when it is an unlimited company, right? If it is an unlimited company, then all the members of that company have unlimited liability to the fund during winding up, right? So in that situation, when you are supposed to bring everything that is needed at the end, that means even for your dues, where you are standing in the queue for your fund, you will have to bring in money to pay off yourself, right? Because even you are a liability to the company, and if the company wants to pay you off, the company will call for the fund from you only. So you will be the person who will contribute and you will be the person who will be taking it back, right? So at the end, because it is an unlimited company, we will definitely settle off all the liabilities, and even your liability will be set off. So before bringing that fund, you can set off that amount which is due to you, which may be due to you on account of any independent dealing or independent contract that has been undertaken between you and the company. So if there is something like that, if you have some money to be taken from that, please settle it off. Now you'll be thinking, he has to bring in, he will settle it off. There's no point, he's getting nothing. He still has to bring in more and more fund. No. Now consider, in this situation, all the members, they have unlimited liability, right? So they have to bring in money in proportion. So if the company thinks that, yeah, they have rupees 5 crore liability remaining that cannot be dispensed off by disposing of the assets, and the company has 50 members, then the company will divide that 5 crores liability within those 50 members. So now suppose each one of them has to bring in 10 lakh rupees, and there was one contributory, one member, even he has to bring rupees 10 lakh, and then in that 5 crore fund, even he is liable to take back some money, and suppose that amounts to rupees 8 lakh. So everybody is contributing for that 8 lakh also. What you do is you set it off. You say, okay, I'll keep that 8 lakh and I'll pay you the remaining 2 lakh. So what are you supposed to pay? Only 2 lakhs. Otherwise also at the end, if you think that no, the company is calling for more money, then again that will be divided among all the 50. So you are actually being paid back. Understand the situation, right? Because that unlimited liability is called in proportion from all the members. So your proportion comes down considerably if you are allowed to set off your amount. So that is the case where an unlimited liability of the contributory, the court may allow you to set off your dues. Similar is the case for the directors. Now this is the case of a limited company. The company is limited, but the liability of the directors are unlimited. We had seen in the list of contributories also the third people, that the managers and the directors who have unlimited liability. Right? Now in that scenario, we know that all the directors and all the managers of the company, or suppose all the directors, they have unlimited liability. So even they are bringing in money in proportion, and a similar law will be attracted to them. When they are supposed to contribute again for that 5 crore rupees fund, there are 50, we cannot have 50 directors, there are 10 directors, right? So each one of them are bringing in rupees 50 lakhs. And this director, because of his independent dealing with the company owes him rupees 40 lakhs. So in that 5 crore fund, 40 lakhs belongs to this director. So if all of them are bringing in money, then all of them are also contributing to that 40 lakh that he will be receiving. So what is his contribution? Divide by 10, rupees 4 lakh. 36 lakh is the extra amount that he is gaining from the other directors. So if he is allowed to set off, he is gaining out of it. You got the concept behind? So in the case of unlimited companies, it is the contributor he is allowed to set off. But if it is a limited company, then the directors or the managers whose liability is unlimited, even they will be allowed to set off. Right? The last part, where creditors have been paid in full. Now, if the creditors are paid in full, do you think that there is any money that you need to bring? Yes, you have. Creditors have been paid. Even you are one of the creditors and you have not been paid. You were the unsecured creditor. You were the contributory. Right? And what is the situation when you say the creditors are paid but you are not paid? Even you were the creditor, you should have been paid. No, this is not that simple scenario. Right? You remember we had talked about that the contributories bring in the fund, 1, to set off those liabilities, 2, to meet the expenditures of winding up, and 3, to balance out their contribution. That means if somebody has bought in more money, somebody has bought in less money, then to equate all of them, the others who had bought in less money will be called for more money, and that will be distributed among other contributories. Right? To balance it out. Now in that situation, you had bought in a lot of money. Now others will bring in those money. All of you will be called, right, to contribute to that fund, to balance it off. Right? So in that scenario, when you are also called for that money, they'll say, okay, you have already bought in so much money, already we have a lot of money due to you, set those off, and then if there is something payable, please pay. If there's nothing payable, wait, we'll pay you back when we get the money from the other contributories. You understand? Now they are balancing it off. So for any subsequent call that is being made after the creditors have been paid, then that call is basically made to set off the contributories, to balance off the contributories, the contribution that they have made. Right? So in that scenario, if you have paid a lot of money, that will be set off now. You will not be allowed to make more contribution because you have already made surplus contribution. Got the point? I hope I was able to explain these 3 scenarios to you in detail. Because as a student, these concepts are not clear with me. Generally, we try to overlook, okay, 3 situations: unlimited liability, unlimited liability for directors, and when creditors have been paid in full. You just read it, you try to mug up, and you proceed. Most of you, be true. Right? I would want you to mention in the comment box whether in the first instance when you had read these topics, for those who have already read it, right, if you have read this topic, did you go into the detail to understand what it is? Maybe from wherever you are reading, whatever books you are following, whatever lectures you are following, whatever teachers you are following, were you able to understand these concepts? Please be true, and I want comments below. So that was all about the topic of contributory. We are done with it. Now before concluding this lecture, right, I would like to discuss 2 questions that have been asked in your examination and which has also been mentioned in a practice manual. Why? Because I'll show you how easy it is. That is the only purpose why I'm discussing it over here, to show you how easy it is. It is not a difficult topic at all. Now since we have discussed it in detail, we know the logic behind, we know the surrounding, we know the entire environment, you will be able to grasp the question within seconds. Right? So the question is on your screen. Number 1, CA Final May 2000. Right? This question was in your paper. I have just given you some bullet points over there. I did not write the entire question because those points are enough. Right? But I would read out the question for you for sure. So the question in your examination said, Messrs XYZ Limited was wound up with effect from 15th March 2000, right, by an order of the court. Now Mr. A, who ceased to be the member of the company from 1/6/1999, that is the previous year, right, has received a notice from the liquidator that he should deposit a sum of rupees 5,000 as he is the contributory towards the liability on the shares previously held by him. That means past members, right? In this context, explain whether Mr. A can be called a contributory and whether he can be made liable and whether there is any limitation on his liability. So what do you think? As we have discussed, right? Is he a present member? No. Why? Because he had ceased. If you remember the list of contributories that we had discussed, the 7 people, what did we say? That ultimately it is all coming out from the member. The member is the person who is giving birth to the 6 items of that list, except that fraud thing, right? So this is the situation where that he was a member, but he has ceased to be the member. So where does he fall? He falls in the list of the past members. But when will he fall in the list of past members? If only he was a member within the preceding 1 year from the date of winding up. So 15th March 2000 is the date of winding up, and this person was a member on 1st June, right? So that was within the period of 1 year, and hence he is into the list of the past members, and hence everything will fall liable on him. You know the answer very well, and now you just have to portray the answer and write it down in your way. Right? Now how do you write the answer? First you will explain what contributory is. Right? So the term contributory means any person liable to contribute to the assets of the company and stuff, all those things you will write. And then you will go on to write, okay, in the list of contributories, past members are also considered to be contributories. When the present members are unable to pay their calls. Pay the amount. When you have called all the money from the present members, still you're not able to pay off the liabilities, then the liability of the past members, they arise, right? You will have to mention that point. And then again you will have to mention those 3 points where the liability of the past member is not attracted. Because the question also asked you at the end that whether there is any limitation on the liability. So yes, there are 3 limitations. If 1 year has lapsed from the day you have ceased to be a member, and then the winding up has taken place after 1 year. Second, there was a contract that was entered after you have ceased to be the member, right? And third, he will be liable to contribute only to the amount that is unpaid on the call. If it is paid, he is not liable, right? So it was that simple a question. And I hope none of you had difficulty in understanding the question and knowing the answer. All of you knew the answer beforehand. Is it or isn't it? I'm talking about those who have seen that lecture of the list of contributories. Yes, you did, right? Now I would show you another question that is also in your practice manual and was asked in your CA final May 2000. It is exactly the same question, 2002, November 2002, right? 5 attempts later you had exactly the same question with exactly the same figure with the years changing and the amount changing. That is it. You want me to read out the question both in your practice manual? If you have the latest practice manual, then the first question is this. This is the first question in your practice manual in the winding up chapter, right? It says, by an order of the court, Messrs. ABC Limited was wound up with effect from 15th March 2002. Mr. Gupta, who ceased to be a member of the company from 1/6/2001, received a notice from the liquidator to deposit a sum of rupees 15,000 as his contribution towards the liability on the shares previously held by him. Mr. Gupta seeks your opinion about his liability. You write exactly the same answer. He is not me, he is some other Mr. Gupta, but you write exactly the same answer. Right? So this is the kind of questions. It is being repeated in your examination, in your practice manual. There is a limited quantity of questions that the institute has. Right? I know for people of the May attempt, they have already given the exams or they are giving the exams. But the people who are appearing for the November attempt, right? You have almost half of the syllabus already done. Within the next few weeks, we'll be completing the entire subject and then we'll move on to discussing the questions. Don't worry, you will be discussed. All the previous year questions will be discussed in the class, at least last 10-15 attempts. All the practice manual questions will be discussed. Why? Because once you have discussed the questions and answers from the practice manual, from the previous years, RTPs and others that the institute may ask from other ways where the concept is very related to this, right? And the questions, even from the CS exams, we'll pick up some questions to discuss. And once you are done with those questions, when you are thorough with the content, when you're done with those questions, then we will also hold some classes whereby we'll summarize the entire chapter in one or two lectures. The entire chapter, because that lecture will be helpful for you during your exams. You can just flip through the questions within a lecture, flip through the entire chapter with one lecture, right? We'll also prepare that. So please stay tuned for that. There's a lot more to come for you to help you out throughout your examination. This will make your law examination very easy, right? Stay tuned. It's been coming up in the next couple of weeks. Until then, this is Abhinay Gupta signing off. See you back in the next lecture. Thank you. Bye-bye.